Appeals in the matter of Pfizer and Flynn Pharma and the CMA.
Ms McLeod.
Good morning, my lords. Back to confirmation bias. Yesterday I dealt with the first part of my submissions, the judgment, so I'm now turning to the second part, which is the authority.
Can I just, before we start, ask you what your interpretation of the judgment is? Did they find actual bias or apparent bias?
In my submission it's not clear because they don't identify which one they are talking about. I say that if it was actual bias, it doesn't meet the test for actual bias. If it was apparent bias, it doesn't meet the test for apparent bias. Neither is clear, but in terms of what appears from the judgment they were finding, it appears to be actual, as I read it.
Confirmation bias assumes that you embark upon an exercise filtering the evidence. You only look at category A and you don't look at category B. I'm not certain you could do that through apparent bias.
There's a complexity in the case law, my lord, in the sense that predetermination, confirmation bias, and actual bias are used occasionally slightly loosely, occasionally in the same breath. What one sees in my submission, it's very difficult to isolate confirmation bias from predetermination. They're at least the same species of concern, where the concern is that the mind has been made up. And the way that the mind has been made up in confirmation bias is by closing one's mind to the rest of the evidence.
The confirmation applies to the evidence collection process.
It does. Whereas predetermination relates to the outcome. And that's something, that distinction is drawn in a case that's not in the bundle in Persimmon Holmes between predetermination relating to the outcome and bias relating to the process. So it's not clear, and I'll pick up a couple of points on that as I go through the authorities, my lord. We don't have, there are many authorities on bias, as you know. But confirmation bias and exactly how one treats that is not dealt with in any great detail in the authorities. The only sort of higher authority that deals with confirmation bias specifically is HCA International, where of course you're looking at it through a different lens, because that was an attempt to stop remission to the same decision maker, rather than allegation post facto that there had been confirmation. So I'm going to take the authorities relatively quickly because I know that these principles will be well familiar to the court. But just to show...
Well, you know, you're not... No one's particularly stretched for time. I mean, there are some analytical questions we have to get our minds around, the framework for analysis of this issue in the context of this decision. So show us what you think you need to.
Okay, well, I'll start with the Condron case, the National Assembly Condron, which is in the first bundle of authorities, tab 21, page 374, and I think page 376 of the electronic bundle. Now, this follows on from Porter and McGill. Porter and McGill is dealt with, and it relates to a statement prior to a decision where it was suggested that there had been predetermination. So the Assembly member indicates that he was going to go with the inspector's report. That's the possible predetermination that the judge identifies, and the judge identifies that paragraph 11. Now, the Court of Appeal overturned the High Court's finding that that had constituted bias. Primary ground of appeal is bias, and that's the fourth ground of appeal. Before I get there, can I highlight a point at paragraph 26, which is at the top of hard copy 384 and electronic bundle 386. What we see here is I am in full agreement as to the importance of identifying with some precision the facts on which the suggestion of bias is based. Coming on then to ground 4, which Lord Justice Richards describes as the central issue in this appeal. Paragraph 38, we see that there's no disagreement as to the correct legal test, and the correct legal test is the Porter and McGill test. So going to the quote, that involves a two-stage process. First, the court must ascertain all the circumstances which have a bearing on the suggestion that the tribunal was biased. Second, it must ask itself whether those circumstances would lead a fair-minded and informed observer to conclude that there was a real possibility that the tribunal was biased. At paragraph 39, Lord Justice Richards considers the judgment in Porter and McGill, from which that test emanates. And over the page, sort of 3 lines down, Lord Justice Richards highlights Lord Hope's finding that while there was room for a casual observer to form the view after the press conference in Porter and McGill that the auditor might be biased, the conclusion to be drawn from an examination of the material before the court was that there was no evidence of bias. Paragraph 41.
Just effectively emphasising that it's a judicial test.
It's a judicial test. The fair-minded and informed observer is not a casual observer. And we will come on to that in Lanes and Gulliford, my lord. The point is, one cannot just look at it and casually observe it. One has to carefully consider all of the circumstances. And that is what this court goes on to do. So at paragraph 41, the court looks for the relevant facts. At paragraph 42, we see the starting point is the actual words found to be spoken, which were put by the judge as, "I'm going to go with the report of the inspector." At the end of that paragraph, over the page, we see Lord Justice Richards' view that when they are viewed objectively and in their context, the words appear to me to be consistent with the speaker having a predisposition to follow the inspector's report. At paragraph 43, there's the distinction that my Lord Justice Green raised yesterday between predetermination and predisposition, which the court endorses. The latter involves a mind closed to the consideration of weighing factors. At paragraph 45, we see that it is necessary to bear in mind the context in which the words were spoken. And at the end of that paragraph, it is a case where the wider picture is particularly important. As to that wider picture, we see at paragraph 46 the inspector's report. Paragraph 48, we see that the court analyses the Commissioner's decision letter as to what happened in the committee meeting. We see that there was a finding that the meeting was unusually prolonged and that the members explored the many issues and representations, which tells against predetermination. In paragraph 50, we see that Lord Justice Richards finds that the judge was wrong to reject as irrelevant the facts that the meeting has been so prolonged, because the court must look at all the circumstances as they appear from the material before it. Those circumstances include, at paragraph 52, a further relevant matter was the qualifications for membership of the committee. And at paragraph 53, there's a little bit more detail about that. In the context of allegations of apparent bias, weight has been placed on the judicial oath of office. But halfway through that paragraph, while the position of members of the planning committee is of course very different to that of judicial office holders, the fact that they have received relevant training and have agreed to be bound by a code of conduct is a consideration to which some weight can properly be attached when determining an issue of apparent bias. Those factors were not considered by the judge. We see at paragraph 56 on page 391 or electronic 393 that the question of whether the decision was vitiated by an appearance of bias is essentially a question of law, requiring a correct application of the legal test to the decided facts, and to answer that question incorrectly is itself an error of law. So the judge's decision was ultimately overturned, as we see paragraph 58. Briefly, my lords, let's now turn to Lanes and Gulliford, which is in the next version of the authorities bundle, bundle 2, tab 28, page 532, or electronic page 534.
Sorry, tab?
28. This case relates...
Can I just ask a question on the facts, which perhaps flows out of some of the argument yesterday about the alleged per se approach to cost plus, which is inconsistent with the language of the decision, express language of the decision.
Yes.
And that's something which the tribunal treats as evidence of bias.
Yes.
Is the tribunal saying that that unarticulated proposition was a deliberate effort on the part of the CMA to conceal its true state of affairs or its true analysis? Because it accepts that there's inconsistency, but it nonetheless finds that the CMA did conclude that anything above cost plus was per se or presumptively unlawful. And it relies upon that as part of bias. Is this maybe a matter of construction of the cap judgment or inference to be drawn? Are they saying that there was a deliberate concealment by the CMA?
My reading of the judgment, and we'll come to the specific paragraphs, my lord, but my reading of the judgment is no. There's not a finding of a deliberate.
Well, no, they don't find it, but what inference does one draw from the fact that they say it was the CMA's position, yet it's inconsistently stated in, was it paragraph 5130, there or thereabouts?
Yes.
What do we infer from that about the cat's state of mind in relation to bias? Maybe you're coming to this.
I am coming to those specific factors
Okay.
in due course, my lord. What I say now is, of course, to echo some of the factors that we've already seen from that decision, which is that one has to identify with precision the facts that go to bias, and that's what one is finding. And that in this case, there's certainly no allegation of deliberate conduct that one sees in that section of the decision. It is, however, a very, very, very serious finding of confirmation bias, whether deliberate or otherwise.
Yes.
So just coming back to Lanes and Gulliford, this relates to a preliminary view expressed by a construction adjudicator, which the court below had held demonstrated bias, so it's a similar set of facts. And again, it was overturned by the Court of Appeal. And just briefly, I want to flag a couple of points in the judgment of Lord Justice Jackson. So can we turn to paragraph 44, which is on page 542, or electronic page 544. Lord Justice Jackson starts by setting out the principles, noting that bias has been defined as an attitude of mind preventing the judge from making an objective determination, and it may arise from a variety of causes, such as a desire to decide a case one way. Over the page, we see that predetermination is sometimes treated as a species of bias, though it is conceptually somewhat different, because it arises when a judge or other decision maker reaches a final conclusion before he or she is in possession of all the relevant evidence and argument. So just pausing here to go back to my Lord Albany's earlier question, there is something of a jurisprudential debate about how one characterises predetermination. But what I would emphasise and what one sees here is that the Porter and McGill test is ultimately applied in these cases, whether it's predetermination or bias. But of course, if one is looking for apparent predisposition, predetermination, that's a difficult test to satisfy.
In one sense, if you predetermine something, you are biased towards a particular outcome.
You are.
It's probably more an aspect of procedural unfairness, because you then embark upon a procedure without having an open mind. It may be
in the same way that bias could be said in the same way. And I mean, for example, Fordham, the most recent edition of Fordham, deals with it in terms of bias. One has actual bias, which can include actual bias by predetermination, and apparent bias, which one can have by predetermination, although some of the authorities indicate that that's very, very difficult. Now, in paragraph 46, there's the trite but important statement that in practice, findings of actual bias or predetermination, to which I would add confirmation bias, are rare. And then just to pick up at paragraph 51, the elaboration of the fair-minded observer test. As he explains, the fair-minded observer must be assumed to know all relevant public available facts, must be assumed to be neither complacent nor unduly sensitive or suspicious, must be assumed to be fairly perspicacious, because he's able to distinguish between what is relevant and what is not. And so in this case, at paragraph 57, the fair-minded observer, with all the admirable qualities identified above, would have no difficulty in deciding that there was not bias. Turning now then to the judgment of Justice Voss, as he then was in HCA International, that's at tab 31, electronic bundle 583. And this addresses the issue of confirmation bias, specifically in relation to the CMA. The scope of the dispute is set out in paragraphs 2 to 4 on pages 561, electronic 585. We see at paragraph 2 that the applicant, HCA, is a major provider of private healthcare services, subject of investigation into the supply of healthcare services by the CMA. At 3, we see that the CMA has agreed that 2 of its main decisions affecting HCA should be quashed by the CAT, but HCA asked the CAT to remit those decisions to be remade by a freshly constituted inquiry group, which the CMA strongly resisted. The main question at paragraph 4 was whether the CAT was right. HCA contended that the inquiry group was incompetent, treated HCA unfairly, and would be affected by either or both of apparent bias and confirmation bias, the difficulty of persuading a decision maker that has once made up its mind to change its view. So just to run over the facts, paragraph 16 at the top of page 564, electronic 588. The CMA had published its provisional findings, including the details of its original IPA, which is the insured prices analysis. At paragraph 20, the CMA wrote to one of the healthcare providers that was the subject of the inquiry, saying that it had made changes to that analysis following comments received. Paragraph 21, it wrote to 3 other providers, but importantly, as set out in the final sentence of that paragraph, HCA was not sent any letter similar to those 11 letters. At paragraph 23, there was the inquiry group undertook an oral hearing where the CMA's representatives did not inform HCA that the analysis had been revised, and it was only when the final report was released that HCA was able to ascertain that the IPA had been revised. That's paragraph 24. Paragraph 31, the CMA made clear that it was minded to concede the quashing of the decisions. And paragraph 35, the CMA solicitors wrote to HCA solicitors rejecting the suggestion of remission to a new inquiry group and a new case team. So those are the facts. Now, of course, stepping back, that is a different position to the current case, because in essence, what HCA was asking the court to find was a proactive finding of bias in advance of the CMA's decision being taken, rather than a post-facto analysis. But one can still draw points out of it. If we can turn to page 577, which is electronic 601, this is in the section where the court is addressing the authorities on remission and bias. Paragraph 64, we see that the relevant authorities on bias are not in dispute, and it's Porter and McGill. There's no separate analysis here of confirmation bias. At paragraph 66, dealing with this discussion on the remission issue, we see that halfway through that paragraph it said that the principles are unlikely to be different as between remission to an administrative body and remission to a tribunal, although there may be different relevant factors arising. At paragraph 72, we see that in the context of remission, it was incumbent on the tribunal to consider the factual circumstances in order to decide first whether remission would give rise to a reasonably perceived unfairness. It goes on to say that these were questions of law, and the question is whether the CAT applied those principles correctly. Moving on to paragraph 87 on page 581, electronic number 605. This is the public confidence ground, and Lord Justice Voss is considering the question of public confidence in the decision-making of an administrative body. We see halfway through this paragraph that it would be a very serious matter indeed if the CAT had taken the view, as HCA urged, that the public could not have confidence in the future decision-making of this inquiry group, comprising as it does of a number of highly experienced professional people. The bias ground is dealt with at paragraphs 90 to 92. Confirmation bias is dealt with separately to apparent bias. There's no reasoning given as to why that might be. So that's dealt with at paragraph 92, and it's dealt with very shortly. I do not accept that there was or is a risk of confirmation bias. The inquiry group is, as I have said, composed of highly experienced professionals. Mr. Whitcomb has made clear that the inquiry group will approach the process of remaking the decisions with an open mind, and I do not accept that the errors, the accepted errors in this case, made in the past process give rise to an inference that he or his inquiry group or the case team would be affected by confirmation bias. Lord Justice Voss deals with confirmation.
Does the word confirmation mean any more than predetermined? I mean, you're confirming through the process the position you have already arrived at.
Indeed.
Which is predetermined.
Indeed.
The confirmation is the description that when you go through the procedure, you do what you do in order to confirm your predetermined outcome.
Indeed, you've already decided the outcome, and through the process you are engineering it such that that will happen. So in my submission, when one looks at, for example, a committee member that says in advance, I'm going to go with the inspector's report, and then goes into the meeting and ultimately finds that in the same way as the inspector's report, that's the same type of thinking, it's the same evil that the concept of predetermination is aimed at.
It can be something different though, can't it? I mean, take a decision maker who makes and gives a reasoned decision, let's say a first instance judge, and the Court of Appeal, on appeal, say, no, you got it wrong because of some legal or factual error, and sends it back. I mean, one aspect of confirmation bias could be that a person might, if they weren't as well professionally trained not to do this, feel a bit miffed that they'd been overturned on appeal and would quite like to, as it were, show that they were basically right all along. Even so, in a sense, it wouldn't be a predetermination. It would just be a sort of, well, you know, what do they know? I would have done it anyway. And now you wouldn't go through that thought process, but that's the suggestion often, I think, of confirmation bias, which is, you know, people just don't like to be told they're wrong and subconsciously want to end up in the same place.
Indeed, my lords. If I may, there is perhaps a distinction between the psychological use of the word confirmation bias or the lay use of the word confirmation bias, which is the understandable predisposition to make certain findings, whether it's as to an outcome or to prove that one is right or all of those things. And there's a different question as to whether or not that amounts in law to bias.
Yeah, I mean, but I was just trying to pick up my Lord's question to you that,
Indeed.
I mean, one of the reasons I suspect that confirmation bias is less likely to be found to be an issue when you are dealing with people who are supposedly trained to bring an objective point of mind to it, is that people who are trained to do a job objectively just take being told they're wrong as an occupational hazard.
Indeed.
And don't feel that they can, as it would, disassociate themselves from it. But the suggestion, I think, might be that if there's a sort of a bit of a mission in an organisation, or a sense of pride in outcome, pride in what you do, subconsciously it may affect, or could be seen to affect, the way people behave when they're asked to do something again. I mean, I I'm not making that referable to this fact of this case, but I don't think confirmation bias is necessarily always just predetermination.
In those circumstances, my lord, what one might be looking at is a more classic case of actual bias, in that what one is looking at is one would have to prove that an organisation was on an organisational mission, or a judge was on a judicial mission to prove they were right. And so if one is looking at that type of finding, the way that would be characterised, it seems to me most likely, my lord, is actual bias. Whether that's a species of predetermination or separately, one can see it. Now, of course, there are a lot of cases around remitting back to judges who've heard things. This is, HCA International is an important authority because it makes clear that an authority such as the CMA is to be treated as a judge would, and is to be treated as understanding the professional responsibilities and understanding that where it's told it's gone wrong, it has to go and look at that. And of course, I'll come to the facts of this case, but that's what one can draw from this authority. And in terms of apparent bias, which Lord Justice Foss does deal with separately, that's dealt with at paragraphs 96 and 97. And even though the CMA had acted in that case in a manner which it accepted was unfair, the court relies in particular on paragraph 97 as to the fact that the case team were composed of experienced professionals that had and have no personal interest in the case against HCA. Taking a wrong turn is not enough, and as we see over the page, errors may have been made, but that did not make the process wholly flawed or fundamentally mishandled. The final authority that I want to draw to your Lordship's attention today is the British Academy of Songwriters, Composers and Authors and others. Just very briefly to flag the point that I indicated I would come to yesterday. That's at page 603 of the authorities second bundle and page 627 of the electronic bundle. It's the final paragraph.
This is tab 33.
It is tab 33, my lord, yes. This is your judgment in the Basker case. And it's dealing with, we're dealing with unlawful predetermination. That's the submission that you're dealing with. You can see that from the top of page 602. And I want to flag the final paragraph at 280. Fourthly and finally, as to the invitation made by the claimants for me to infer from the end result that the minister had apparently predetermined the outcome, this is to elide two different matters, which are the drawing of incorrect inferences from the evidence and the decision-maker's thought processes. I accept that one component of a conclusion that the decision-maker has unlawfully closed his mind, factor discretion and predetermined a matter might in principle be a finding that unwarranted inferences were drawn. However, in this case, the conclusions would have indicated to the minister that he could legitimately proceed to introduce the copyright exception. The fact that the Secretary of State erred in this regard does not prove predetermination or the appearance thereof. It suggests only that the Secretary of State erred. It will thus be rare for inferences of this type to amount to conclusive evidence of predetermination. The evidence may suffice to amount to a rationality challenge, but it does not prove predetermination. So stepping back from those authorities, there are 6 points that I would emphasise to your lordships. The first is that the question of whether or not a judge was correct to make a finding of bias in relevant circumstances is, as the courts have described it, a question of law. That's Condren, paragraph 56, and HCA, paragraph 72.
Sorry, Condren
56.
and
HCA 72. Second, a finding of actual bias or predetermination is rare. It is serious. It's Lanes and Galliford, paragraph 46. Third, the courts will accord weight to judicial oaths when considering considering bias in tribunals or courts. But that weight is not reserved for tribunals. It also applies to bodies such as the CMA, as we saw from Condren, para 53, and HCA, para 66. Fourth, in order for a finding of bias to be made.
Can I just ask you about that one in a little bit
Yes.
more detail? Obviously, the CMA doesn't take a judicial oath, but it's subject to a statutory duty of fair.
It's subject to a statutory duty, and as we'll come on to, a statutory framework which requires independence within its decision makers. So it's not to say that the same weight will necessarily be applied, but the same accordance, the same deference, the same understanding that this is a professional body will apply to the CMA.
I mean, isn't that just a matter of fact? I mean, are you saying there's a legal matter that we have to give deference, or do we just not? Do we not say, well, as a fact, this body has a statutory mandate, and people who work in it are presumably aware of it, and we presume that they will, unless demonstrated otherwise, that they'll act in accordance with it. But why is it a fact? It's not legal, is it?
What I say is, as a matter of law, the tribunal that one is looking at, the qualifications of that tribunal is relevant. As a matter of fact, what those qualifications are will depend on the individual circumstances.
It's something we can take into account.
Indeed.
Yeah. And actually, by the same token, I think you said under number 2, you said actual bias is both serious and rare. I think we ought to. I think I'd accept actual bias is serious. Actual bias is rare. I mean, that's just an observation on the difficulties of proving it, isn't it? Rather than
It is. That's where that comes from.
One hopes it's rare.
One hopes it's rare. Was that number 3 or number 4?
That was number 3. We're now, I think, starting with number 4.
Number 4. In order for a finding of bias to be made, the courts must identify with precision the facts on which the suggestion of bias is based. That's Condren, paragraph 26. And thereafter, the court must consider those facts as against the wider factual background. Fifth.
Hang on.
For actual bias or predetermination in particular, one has to show not only that there was predisposition, but predetermination. That the decision maker is immune to contrary argument. Prior statements or prior decisions are very rarely enough by themselves. 6.
And I'm not sure that's right, actually. I mean, predetermination, I agree. You need to show that somebody's immune from contrary argument. If you're just talking about actual bias in a more general sense, it's an inability to bring an objective mind to the question, isn't it?
That may be a relevant distinction, my lord. I can see that.
I mean, I think you either deliberately or inadvertently rolled the two into the same proposition. I'm not sure it's quite the same.
If I may, my lord, in rolling the two together, the reason for rolling the two together is that what one sees in the analysis, where an allegation is of predetermination, one falls back on the bias authorities. So you get Porter and McGill being relied upon in the context of predetermination.
Yeah, I think all I was picking you up on, and it may be that it doesn't matter, but I fully understand that if you're saying, if the allegation is one of predetermination, the question is, had somebody closed their mind, were they immune to contrary argument? I would understand that as a proposition. If you're saying the allegation was of actual bias, it could be satisfied simply by showing that somebody had a predisposition that meant that they couldn't bring an objective mind to bear on it, but not that they'd predetermined.
I would accept that, my lord.
So which is this? Are you equating the paragraphs of the CAT's judgment, 280 and onwards, to an allegation of predetermination?
in a sense, my lord, it's very difficult for us because what's said is that there's a finding of confirmation bias. What the court means by that is never clear. It doesn't say this is actual bias, this is apparent bias, this is predetermination.
But what are you saying it is? Because you're telling us what the test is, and so far it seems to be you're relying on the cases about predetermination.
Well, as is set out in our skeleton argument, essentially one takes a very similar approach, certainly when one is looking at apparent bias, because whether in predetermination or bias, the test for apparent bias is always the same. When it comes to whether or not what the tribunal is finding is predisposition or is a bias or predetermination, it appears to us that what it is finding is in essence predetermination. But the CMA had decided, but it may be that it's a finding of bias. It's difficult for us to know. That's one of the problems that we have with the judgment.
I read it, I think, as predetermination, not least because of the first matter they rely upon, namely that you adopted a per se approach, which they then said reversed the burden of proof and created a presumption of guilt, if you like.
Indeed. And so, if it is predetermination, then it does have to meet that high test of not just predisposition, which my lord will just know.
But if it was predisposition, then one would say, what's wrong with that? You're entitled, you're entitled to have a predisposition. To say that's what you put in a statement of objections.
Indeed.
This is our predisposition, and this is your target. You know,
Indeed. Knock
this down, and of course we will keep an open mind. And if you're right, and we'll change our view.
Indeed, in any investigation,
Well, every consultation paper issued by the government has a predisposition. I mean, they're entitled to, and actually it's generally said that a predisposition fosters good consultation because you give the consultees a target.
Indeed.
They know what you're thinking.
Indeed. And it's the same for investigations, my lord. It's an important part, it's part of the Article 6 rights of the undertaking, that there is an indication in advance in a statement of objections as to what the preliminary findings of the decision maker are. And then they are ultimately tested and considered, and a final decision is made.
And what is fundamental is that the decision maker must, at the point in time at which they embark upon the process, keep an open mind and operate a fair procedure.
Indeed.
And then be able to change your mind.
But if the decision maker does not change its mind, that does not reveal predetermination.
No.
There needs to be something more.
There's got to be a fair procedure which then leads to a fair result, subject to appeals, etc., etc.
So we'll come on to the facts of this case, my lord, in 1 second, but I believe I've got to give you my 6th point, which is that for apparent bias, there's a 2-stage test, which is that all of the relevant circumstances must be considered, and then the court must consider whether those circumstances would lead a fair-minded and informed observer with all of their admirable qualities to conclude that there was a real possibility of bias. So then turning to the third part of my submissions, which is the background. The starting point in my submission is that the regulatory system has particular safeguards built in. It may be worth turning this up briefly. It's in the first authorities bundle, tab 6, page 75, and it's in the electronic bundle, page 76. This is the Competition and Market Authority's Competition Act 1998 rules. So it's the rules under which decisions are made by the CMA. We see at paragraph 1 that there is to be a relevant person who oversees the investigation under the Act and who is to decide when a notice of a proposed infringement decision under Rule 5 is given. Then there is to be a different relevant person.
I'm sorry, tab 6?
Yes, my lord. Page 75. Do you have it?
So is that electronic 75?
76, I believe, in the electronic bundle.
In the actual bundle, I've got 1998 order, no, 2014 order. Paragraph 1, Article 1 says citation and commencement. Is this in a
Page 76 of the electronic bundle seems rather remarkably to be page 76 of the printed bundle as well.
Some mistake.
Some mistake, surely.
And is that legal advice, my lord?
It is, yes.
Go back a page.
To 75.
Delegation of
Delegation of functions,
Got it.
paragraph 3. Thank you for bearing with me. So start again.
Schedule 1.3.
Schedule 1, paragraph 3.
Yep.
Delegation of functions. Number 1, there is to be a relevant person who oversees the investigation and who is to decide whether notice of a proposed infringement decision, an SO, is given. Paragraph 2, subject to settlement rules, there is to be a different relevant person from the relevant person referred to in paragraph 1 who has not been involved in the investigation, who decides whether any supplementary notice of a proposed infringement decision under Rule 5 is given, whether to make an infringement decision and whether to impose a penalty. And for the purposes of paragraph 2, the different relevant person must comprise at least 2 people. So that is the case decision group, which is fundamentally required to be independent from the team. Now, in this case, the original decision was taken by the case decision group in 2016. The case decision group consisted of Professor Philip Marsden and Dr. Jennifer Haydock, the economics director. If you need reference to that, it's in the supplementary bundle, page 17. Of course, as you all know, the tribunal in the first trial remitted the matter of abusive dominance back to the CMA, with a particular example given of the need to understand the evolution of the tablet market. That decision to remit was upheld by this court, subject to the guidance given in its judgment. At that stage, just for the avoidance of doubt, there were no submissions made that the matter could not be remitted to the same case team, as was the position in HCA. It was therefore remitted back to the CMA, who conducted a lengthy further investigation, and indeed one of the complaints was as to the delay in that investigation. It was a detailed investigation that's summarised at paragraphs 1.97 to 1.111 of the decision, page 978 or 1053 in the electronic. And there was some correspondence in that period, but there were no complaints to the procedural officer. Following the investigation, further SO, the further penalty notice, it was for the case decision group to take the final decision. That case decision group was composed of 3 highly experienced professionals, Paul Hughes, Cyrus Mater, and Julie Bond, pages 1408 or electronic 1483. None of that case decision group were involved in either the 2016 infringement decision nor the remittal investigation. Of course, they couldn't be involved in the remittal investigation under the rules. Now, at trial, the procedural fairness of that new decision was raised by Pfizer in its ground 4. Now, what Pfizer says in its written submissions is that this was not raised lightly. It's not clear to us what that means, as we're assuming Pfizer is not intending to waive privilege, but insofar as Pfizer is addressing the degree to which it was raised at trial, to say that it was raised lightly is, in my submission, to overstate it. In terms of pleadings, there is very little. In Pfizer's notice of appeal, we see that Pfizer indicates, we can turn it up if it's helpful.
I think it's all set out in your skeleton
It's all
argument.
set out in my skeleton argument, precisely. There is an introductory section as well as the section at paragraph 112, but all that does is indicate that Pfizer wrote to the CMA and said that the CMA did not act on that warning. That's paragraph 62, 63.
I think there were in the grounds of appeal, Pfizer raised 2 points. One was
The
press
public
statements, and the other one was, if you like, the conclusions arrived at, working backwards.
The way it puts it
Although it was
is
very
it's
briefly
approach
put.
to the evidence.
Approach to the evidence, yes.
That's the way it's put.
Yeah.
Now, there's no discussion of that in more detail, particularly in the CMA's defence or the reply. When it gets to trial, there are 2 paragraphs in Pfizer's skeleton, but the CMA has searched the transcript for references to confirmation bias, and it cannot find a single clear reference to that principle, none to the law. There are a couple of comments about mindset or themes, that kind of thing, but there's nothing. Now, of course, Pfizer had the points in its NOA and it was entitled to raise them how it saw fit in front of the tribunal, but it illustrates how little assistance the tribunal was given as to the relevant standard. Now, Flynn, of course, did not advance this argument at trial. To do so would have been contrary to the case that Flynn was advancing, which it was that the CMA had taken an volte-face approach in the use of the rocking. So, to turn now to the fourth part of my submissions.
You could engage in a volte-face and still predetermine.
Yes.
One could, but it was not an argument made by the judge.
Yeah.
So to turn back to the judgment, paragraph 2H1, so that's core bundle 3, page 875, internal judgment number 237, and electronic bundle 950.
So 950.
950.
Electronic 950.
Is that correct? Of the core bundle.
Yep. Thank you.
I want to start with what we don't have here. There is no analysis of the relevant test. There's no analysis of whether this is actual or apparent bias. There's no consideration of whether there's a predisposition or predetermination. And there's certainly no analysis of the two-step analysis in the Porter and McGill case law for apparent bias. Moreover, there is no analysis of the key factual background. There's no mention, still less consideration, of the fact that first the remittal was mandated by the court in order that a further decision be taken in this very case. There's no mention of the fact that the remittal did in fact lead to very considerable further investigation. There's no mention that in fact the remittal was to a professional body held to the highest standards with a statutory duty to protect competition for the benefit of consumers. There's no mention of the fact that the decision was, in a number of key respects, substantially different to the first decision. In particular, taking Pfizer, the CMA increased the reasonable rate of return from 6% to 10%. That's the decision, paragraph 5.143. There's no mention of the fact that the remitted decision was taken by a different set of decision makers, independent to both those who made the original decision and those who worked on the remittal investigation. And there's no mention of the fact that there was considerable regulatory safeguards in the decision making. So these factors are not mentioned at all, and as we've seen from Condren and Lane and Gulliford, in my submission, that is sufficient for the judgment below to have erred in law. As to the factors that are addressed, there are three introductory points. First, I would say that the tribunal considers in paragraph 281 that it has already identified the factors that underlie its decision. However, firstly, the fact that other sections of the judgment are relied upon which go to the correctness of the CMA's findings does not assist the court with bias. However, in any event, it leaves the CMA in an invidious position because it is not clear what sections they are relying on. Second, my second introductory point, the findings that follow are not the criticisms that Pfizer identifies in its notice of appeal. And third, an introductory point that I'll come back to, I would ask your lordships to bear in mind as we go through these findings, a thought experiment, which if this was a simpler scenario where there had been an SO and then there was a decision, would these findings amount to confirmation? So turning to the findings that are made, the first is at paragraph 281.1, and this is the question of whether the CMA has been over-influenced by the arrangements between Pfizer and Flynn. Professor Bailey has addressed this. We, of course, say that there was no error. However, in any event, this does not amount to a proper basis for a finding of confirmation bias, the type of error identified in Basco. The second factor is at paragraph 281.2. Can I invite you to read this paragraph, because I confess it's a little dense and we struggle with the reasoning.
So 2812.
2812 on internal page 238.
Yeah.
The essential criticism seems to be that the CMA did not conduct a, quote, true and fair examination.
There are two criticisms as I read it. The first is that the suggestion that relying on price increases shows bias. And insofar as that's relied upon, that, in my submission, cannot be right, because the Chancellor was noting that while there is a need for a rigorous approach, the stark reality at the heart of this case cannot be forgotten.
That can't be the criticism, because the first sentence is that should not be disregarded.
Indeed.
Yeah.
It's a little difficult to read that. But what is said halfway through the second part of the paragraph is the fact that prices increased is therefore not of itself particularly surprising. It's not clear whether that's a criticism of reliability. The second criticism is, as my Lord Green articulates, or Justice Green articulates, is that insofar as this is suggesting that the CMA had not considered the relevant market, we don't understand that criticism. Because the relevant market is, of course, the relevant market for capsules.
Sorry, just to pick up my Lord Justice Zacaroli's point.
Of course.
He just drew attention to the first sentence.
Indeed.
Saying the fact that price increases of a dramatic nature occurred practically overnight is a factor impossible to disregard and one that should not be disregarded. Quote from the Chancellor: "This was a criticism levelled at the decision in Phenytoin I." So in other words, as I understand it, the criticism was levelled at the CAT in Phenytoin I that it had forgotten the dramatic increase, which it was, quote, important to keep in mind.
That would be one way of reading it, my Lord, and it makes more sense to do so. However, the difficulty is, of course, that the second part of the quote is what is highlighted by the tribunal. So what they're highlighting is that did not abrogate the need for a rigorous, reasoned approach.
But it was important to keep it in mind.
Indeed, and that appears to be what is then carried through in the analysis after as the factor that it's important to keep in mind.
So what does the CAT then mean? It can equally well be made of the decision itself. What does that mean?
My understanding of what the tribunal is saying is that the tribunal is saying that the criticism that a sufficiently rigorous, reasoned approach had not been taken by the CMA can also be can be made of the decision the second time around. But insofar as that's what the tribunal is saying, that's a misreading of the Chancellor as he then was his judgment. So just to come back to the point on market, the market is the market for capsules. That the CMA investigated fully in its first decision, and Pfizer and Flynn were found to be dominant. So there can be no suggestion that the CMA hasn't undertaken an analysis of that market.
Of course, I mean, the second decision proceeded upon the basis of the product market finding
in the first
decision one, which is not in dispute.
Indeed.
So the market was analysed for the purpose of defining the product market and the position of the parties in it.
Indeed.
So it takes you to the finding of both of dominance.
Indeed.
And so it can't be. I mean, that is a finding of dominance. Does assume that might assume that the market is not, quote, working.
Indeed.
So quite. What does that mean for abuse, which is the subject matter of the second decision?
Well, if it's what it might be meant as, my Lord, is a sort of non-technical sense, where the CMA is considering the reasons that there was switching. But as Mr. Holmes addressed you on yesterday, the CMA did look at market structure in relation to its consideration of whether or not the prices were unfair, and was criticised for doing that. It may also be a reference to tablets, but of course, as was canvassed yesterday, that was covered in a great deal of detail in the decision. So whatever it can mean, it doesn't make sense, regrettably, to the CMA.
Boils down to it was not fair nor true. The analysis of the nature of the abuse that might or might not have taken place was the reasons behind the fact that the market were not working, were not articulated in a fair and true manner.
Indeed. If that's what's said, we respectfully disagree on any meaning of market.
I don't know where you are in the paragraph, but I have also a problem with just trying to understand, and it may just be me, the sentence, well, there's a number of sentences in the middle of this thing. It says, the fact that prices increased is therefore not of itself particularly surprising.
Indeed.
It was expected that generic competition would subsequently keep prices under control. That did not happen. And it may be that this absence of generic competition is an indicator of competition law infringement. Okay, understand that. In the way that substantial price increases are not. So, is the CAT saying that substantial price increases are not an indicator of competition law infringement?
That appears to be what's being said here. And insofar as it is flatly inconsistent with what the Chancellor was saying. And indeed, the starting point of the paragraph.
Well, that was, yeah, okay, well, you. Right, so you're as mystified as I am at the moment?
Respectfully, yes.
Right, okay.
We say whatever it can mean, not only is it wrong on its own terms, it certainly does not amount to bias. Paragraph 2813, as far as we understand the criticism here, in essence, the tribunal is saying that CMA was wrong to consider the differential in price and the relevant price increases at the unfair limb, and comes back to this idea of producer surplus. Now, of course, on this, Mr. Holmes has already addressed you on why the CMA was not wrong to consider cost plus points at the unfair limb. And the decision deals in great detail with the reasons for the differential.
But I understood this to be a reference to their conclusion that the CMA considered that anything above cost plus was unlawful, and they therefore said that is evidence of bias both at the excessive limb and the unfair limb.
Yes, that's correct. And
when they refer to a cost, only ever saw this as a cost plus case, I think they're referring to their analysis of the CMA's view as being per se at the level of cost plus.
I would agree with that respectfully, my lord, and thank you for picking me up that it's both excessiveness and unfairness that is in.
Just out of interest, where is CMA cost plus, capital, actually defined?
Oh.
Paragraph 32, subparagraph 4.
Paragraph 32, subparagraph 4, I'm told by Professor Bailey.
Do you mind just waiting a moment so I just understand what this is actually trying to say? 34 sub 2.
It's page 660 of the hard copies. It's 735 on the electronic bundle, and one doesn't really get a great deal of further assistance from this, if I may respectfully say so, my lord, because all that's said is, in assessing whether the appellant's prices were excessive, the CMA adopted a cost-plus approach, which appears to stem from the previous paragraph, which is just the United Branding Standards test.
Well, it's CMA cost plus is a convenient label for identifying, without necessarily endorsing, the CMA's approach.
Indeed.
And when I read this, I thought, well, what do they mean by approach?
And maybe that comes back to the per se approach.
So when it, sorry, give me the page reference again. We go back to 281 at
735, or the confirmation bias page number, my lord. That's 950, I think.
950, yeah. So when we go back to this paragraph, So when it said the CMA, as the decision makes clear, only ever saw this as a CMA cost plus case, that does seem to be passing it, saying that the CMA's approach was, this was cost plus? I don't understand what is it trying to say?
There must be, I think, for it to make sense, my lord, an importation of a criticism of this. It's not just the United Brands approach. It must be the inference that's made throughout the decision about the CMA's cost plus approach being a close-minded per se.
Okay, so this is a it's a unwilling to accept anything other than cost plus being appropriate.
That appears to be the case.
And apparently, as the decision makes clear, any idea where the decision makes clear that the CMA only ever saw this as?
Well, we would robustly say that the CMA did not only ever see it as a CMA cost plus approach, insofar as that is meant as a criticism of a close-minded or per se approach.
But presumably you say, we've got this Professor Bowler's submissions on why that's not the case, but presumably your submission is, even if he's wrong about it,
Precisely.
it's a mistake.
It's a mistake.
Yeah, it's wrong,
It's an error.
but not bias.
Indeed.
Yeah.
And the same goes for
I think that the
2A.
definition of cost plus approach, and I'm just checking my notes, in the judgment, I think you find that at 195, and then it tracks through 205, 206, 228 and 245. One, I suppose 205 is where the cat refers to the per se approach.
Yes, in paragraph 195 there's an a priori
Yeah.
erroneous view. And in 205 it's that we're wedded to a cost plus approach and a per se system. So coming back to paragraph 2814, the same criticism in my respectful submission applies, because what's said here is that comparators were disregarded. Mr. Holmes has already addressed the fact that they were not disregarded, but even if they were, that does not amount to bias.
Well, I suppose that potentially could be what we understand colloquially as confirmation bias. You don't look at something because you've already reached a provisional view that this is correct, and therefore you needn't go any further.
It could be, but then, my lord, what one would have to do is consider in all of the relevant circumstances, which the tribunal does not do, whether or not that is in fact an impermissible level of bias. And so coming back to my thought experiment, in my submission, if these errors had arisen in a case with a more simple factual background, where there was an SO and then a decision, none of these would amount to bias. Because indeed, if they did, that would lead to a position where almost all errors taken by the decision maker amount to bias if they're repeated. So in my submission, the tribunal has gone wrong, and it was not given the tools to analyse confirmation bias properly, and it did not do so. Whatever test it was purporting to apply, it did not do so correctly as a matter of law.
Just on 4, subparagraph 4, the reference to comparables.
Yes.
Cat's view seems to be comparators were, quotes, essentially disregarded.
Indeed.
And then we discussed yesterday the fact that some comparable pharmaceuticals were priced at similar levels, not determinative material, and did fall to be considered, and therefore the assumption was ignored.
Indeed.
And therefore confirms bias logically by predetermination.
That seems to be the logic, yes.
And confirmation because you excluded of this
Relevant factors.
excluded relevant factors.
Well, one has to be careful with that, of course, because a common suggestion that is made is that a decision maker has excluded relevant factors. That will not necessarily amount to bias. It will depend on all of the circumstances.
Well, it comes back to the point that even if each and every one of these was made out as a proposition of law, that might be sufficient to set aside a decision, but
Indeed.
it doesn't in and of itself show bias. It just means it was a bad decision.
Indeed, and certainly one would have to consider it in respect to all of the other circumstances which arise in this case.
So, I mean, if I was to write down just errors, if there are such, it's just not indicative of bias without something more.
Indeed.
I mean, it's something we're all very familiar with. You know, we make a decision
We regularly make
on
errors.
paper.
Surely not.
We make decisions. I mean, on paper, and then we come back and the allegation is, well, you didn't find in my favour. You must be biased.
Indeed. It's a really dangerous way of looking at decision making, if I may respectfully say so. And it's not fair to the CMA. Unless I can assist you further, those are our submissions.
Thank you very much indeed. I'm just wondering if Miss Breckenridge is going to follow on. We've had everybody else.
I'm not.
Sorry. No.
Alas.
Alas.
Not on this. Yorick, I knew him.
That's what
The ratio.
There's always no.
I'm just on timing. Clearly, there was an order from the court saying that CMA has 50% of the time and we have 50% of the time, and it's 25. There's only about an hour left for the an hour and a bit for the CMA to have if it's a 50-50. But I'm sure
I think they've finished, haven't they?
well, they need maybe a response.
I'm sure someone will keep time.
Keep time. Whether it's a bad decision or confirmation bias, I wish to open Pfizer's response by highlighting five material errors made by the CMA in assessing the demand-side evidence on unfairness. So I want to emphasise 5 material errors by the CMA in assessing the demand-side evidence on unfairness, Lim 1. And I'll list them and then I'll go through them. The 5 material errors are: first, the failure properly to evaluate the medical evidence. The failure properly to evaluate the medical evidence. Second, the failure properly to evaluate the evidence of the £30 agreement. So the second error concerns the £30 agreement.
That's the Teva price.
The Teva price, the intervention. Third, the failure properly to evaluate the avoided healthcare costs. So the third error concerns the avoided healthcare costs. Fourth, the failure properly to evaluate the tablet price. And fifth, the failure properly to evaluate the prices of other AEDs. AED, anti-epilepsy drugs. So we got first medical evidence, £30 agreement, avoided healthcare costs, tablet price, and AEDs. And in essence, Pfizer's submission is the way that the CMA treated this evidence results in the decision being, in quotes we've just seen, a bad decision, and then it will be a matter to determine whether the way that the evidence is disregarded and dismissed supports Pfizer's ground 4 on confirmation bias. Because we say the only rational and logical approach for the CMA was, on all this evidence, to have found a price in excess of cost plus, because the evidence was so compelling. Before I go to the 5 material errors in the second
So
infringement,
can you just, sorry, because I was,
I beg your pardon.
that last sentence, can you just say it again so I got it down, make sure I've got it down correctly?
Well, it wasn't written down, but I will say it. It was a bad decision because there were errors in assessment.
Yeah.
But the way that the CMA disregarded the evidence, we say, supported our confirmation bias notice of appeal, because the evidence was so compelling.
Yeah, it's the next sentence actually that I didn't get. You say the CMA should.
So it was so compelling that the only logical and rational decision would have been to have found a price above cost plus.
Do you mean your price? Your price was fair.
Well, the burden is not on us to show that it's fair, although
Yes,
we
it's
say
not
we
unfair.
did, but it's not unfair.
Yeah.
There was compelling evidence to show that the £2, whatever it is, £2.83, the different cost plus price, was far too low. Far too low.
Is that enough for you? For example, if we come to the conclusion that yes, it would not have been unfair to price at something above cost plus, but not very far above it, that's not enough for you, is it? Because it still follows that your price is unfair.
Well, I want to go to the how the Court of Appeal treated the first decision, but in answer, if the error of assessment is material, then the decision has to be set aside. So, did the error make a difference? We do not have to show that
Make a difference to what question?
to cost plus. Should the CMA have looked at a price in excess of, say, £2, and the evidence is absolutely compelling that the low cost price is too low.
But as my Lord put to you, does a finding of that, is it enough for you?
Well, the straight answer is yes. If the error of assessment is material.
Material to the finding that your price was unfair is the question.
I beg your pardon. The material to the finding that any pricing above cost plus was unfair. If one sits back, we have a very low cost plus price of £2, and Pfizer charged Flynn between £11 and £13. We'll come on to the prices in a moment. So we have a cost plus price of £2, and Pfizer, in September 2012, charged Flynn £13, and it was reduced to £11. And the prices that Pfizer charged Flynn and Flynn charged to the market were comparable to the 3-tablet prices. 50% lower than the price agreed by the department. So we have adduced significant evidence of a headroom by which you can safely say that the decision, which is based on the CMA's cost plus, is defective. It should have considered, the CMA should have gone on to consider the prices of AEDs, the prices of the tablets. It should have considered the relevance of the department's agreement, which I'll come on to. It should have gone on to consider the value of the medical evidence. It is not for the undertaking to prove that its price of £11 is fair. Its primary task is to show that the CMA has made a material error in assessing the evidence. That is, the infringement is based on the CMA's cost plus, and I'll develop this. And in order to share my lords' point, it is important to have a look at the first infringement decision and see why the first infringement decision was set aside. And can we go to the the material errors in the first decision? We can do this by going to the first tribunal judgment.
Just before we go on, do I understand you therefore to say that if the CMA should have come to the conclusion that a price of £5 was not abusive, then the decision should be set aside, which found that your price of the ultimate price of £50+
Yes, if
was unfair.
If this court concludes, goodness, in the light of the evidence concerning these 5 factors, the value of phenytoin is clearly above the cost plus price, then the decision should be set aside for a defective evidential evaluation.
Yeah. So, I mean, this is a point which we're aware of, and I raised with counsel for the CMA yesterday. They accept that even if there's no evidence of value or benefit, but the comparables suggest that prices are much, much higher, then that would mean that your price charged by a dominant undertaking is still fair.
Well, it's not unfair. Yes,
It's lawful. It's lawful.
It's lawful by virtue of the fact that the CMA's investigation has been its decision has been set aside because it hasn't properly evaluated the economic value of phenytoin.
So it does boil down to the facts and the evidence.
Yes, it does. And that's why we say there's no discernible error of law in particular, because the tribunal has properly concluded that there were material errors relating to the 5 factors that I've just identified.
Okay.
And just to show my lords the question of a defect in the evaluation, can we go to the CAT's first judgment? This is at Core Bundle 2 at tab 30. But if we go to paragraph 269, that's at page 500, and the EB, I'm told, is 575. So hard copy 500, EB 575.
This is core bundle.
This is Core Bundle 2. Yes, I'm sorry. Core Bundle 2. Core Bundle Volume 2, tab 30. And EB 575, hard copy 500. I just want to highlight to the court the errors that were identified by the tribunal in Cat 1. So 269, the tribunal says, having found Pfizer and Flynn's prices to be excessive throughout the relevant period, the CMA went on to consider whether those prices were unfair. It first assessed the economic value of Pfizer capsules. We discussed the concept of economic value in detail below. And this is important. For the purpose of this summary, we simply note here that the approach of the CMA was to determine whether there was any non-cost related factors which would increase the economic value of capsule product beyond Pfizer's cost plus. The CMA concluded there were no such factors. And just pause there and then go to paragraph 270. The CMA went to consider and reject a number of factors put forward by Pfizer and Flynn in support of their arguments that the economic value of Pfizer-Flynn capsule was above cost plus. In particular, it rejected the submission that the economic value of phenytoin should take account of the therapeutic value to patients, that's the medical evidence, nor did the value placed on tablets by the NHS, namely the drug tariff price of tablets, provide a basis for assessing the economic value of phenytoin sodium. So that was the That was the situation in the first decision. And these two paragraphs summarise the CMA's assessment that there were no factors justifying a price above the CMA's cost-plus price. No factors. The tribunal found at least two material errors in this. First, the assessment of the tablet price, and second, the assessment of the medical evidence. On the comparator tablet price, if we just move on to paragraph 379 at page 534, which is EB 609, but hard copy 534 EB 609. I'm not going to take this too much because this is obviously the first decision, but it is important to see why the first decision was set aside. 379. This concerns the tablet price. It is apparent from the above that the CMA clearly gave some consideration to the suitability of tablets as a comparator. However, it is not clear to us that it did so in sufficient depth. We emphasise that the purpose of the comparison at this stage of the analysis is to see whether what has been found to be a price influenced by market conditions is restricted as unfair. Given the inherent difficulty in making assessments in this area of competition law, it is all the more important to conduct a full and proper examination. And I'll just leave it there. If I go on to the medical evidence is discussed at paragraphs 411 and 412. That's page 543 of the hard copy, 618 of EB, 618 of EB. And this is where the tribunal, all those years ago, is criticising the CMA for affording insufficient weight to the medical evidence. In our view, although specific guidance on ascertaining economic value is limited, it's essentially a matter of judgment with appropriate weight being given to factors on both the supply and demand side. So the whole exercise is about weighing up demand and supply side. That demand side factors can be taken into account as a matter of law was not in dispute. The question is whether the CMA was correct on the facts of this case to exclude from its calculation of Pfizer and Flynn's economic value all factors other than those that form part of the cost-plus calculation. So that was the exam question, and the tribunal says the CMA was criticised by the parties for not considering patient benefit, although it did indeed describe in broad outline in the decision the nature of epilepsy and phenytoin's role in its treatment. The CMA has not, however, contested the evidence of Professor Walker, that's Pfizer's medical expert, and has in effect conceded that phenytoin remains a useful and effective treatment for a significant number of patients. That being so, we find the outright rejection of any value at all to patients surprising. And the tribunal set aside the decision because the CMA had afforded no weight to the tablet price and no weight to the medical evidence, the therapeutic benefit of phenytoin, beyond that contained in the cost plus. And we know that the CMA appealed the setting aside of the decision on that basis to this court. And the Court of Appeal's judgment is at tab 31. And just for my Lord's note, if we go to tab 31 at paragraph 151 on page 610, that's EB 685, EB 685. Paragraph 151, my Lord Justice Green sets out what the tribunal decided, and then at 152, in my judgment, it follows from the above that the tribunal's findings were made within its jurisdiction. It specified the areas where it found the evaluation lacking. It was not bound by the CMA's margin of manoeuvre. It explained why, in its view, the error would be material. I can detect no error in the approach adopted by the tribunal. So there was no error of law and permission was refused. And that's why the tablet issue was remitted. On the medical evidence, if one goes to page 613, which is EB 688, again this concerns the medical evidence, so hard copy 613, EB 688. My Lord sets out the tribunal's assessment on the medical evidence, and then in the analysis at 165 over the page, I do not accept this ground of appeal. The tribunal made findings of fact which it was entitled to make and which are not capable of being challenged. Therefore, no error of law, and the decision, the setting aside of the decision was confirmed. And the CMA cannot have been under any illusion that a defective remittal assessment of the demand side evidence could lead to the setting aside of the remittal decision, and it could not have been under any illusion that on appeal it would need to identify an error of law. And with that, I put the...
You seem to have added some sort of qualification at 166. I don't remember it.
Is that remote? Has it got the word remote?
So you say the CMA must have known that it needed to do a proper review of the evidence.
Yes.
What was the second proposition you put?
And it cannot have been under any illusion that if there was a defective assessment, it would need to identify an error of law, because the tribunal finding as a fact that the evaluation is defective is a question of fact. The tribunal is saying you haven't weighed up the demand and supply side properly. This evidence is clearly relevant. You've left it out of account.
Yes.
That is a finding of fact by the tribunal, which on the authority here is a finding of fact, not an error of law.
So what did the CMA need to have in its mind? I understand it needed to have...
When I go...
It knew that it needed to do a proper review of the evidence. What's the second thing the CMA, you say, needed to have in its head?
It would know that if there was a defective assessment,
Of the
the
evidence.
chances of overturning that would be, in this court today, would be slim, because they have to show an error of law, not fact.
Okay, I think I understand. So you say the CAT made findings of fact about what the CAT did. Prima facie, those are not justiciable as errors of law in this court.
Yes.
Unless, so the CMA have got to identify, for example, if we construe the judgment as saying the CMA didn't do anything, and yet we find that they did, that's a question of law because it's construction of the decision.
Well, no, I don't. With respect,
Where's the line between those two?
In the first decision, the CAT set aside the decision because the tablet price and the medical evidence had not been examined in sufficient depth. So the CMA had looked at tablets and had looked at the medical evidence, but had not conducted an examination in sufficient depth. And when we come to see the errors, in my respectful submission, the demand side evidence was compelling to show to the CMA that simply having a price based on cost plus was not appropriate.
Okay.
Can I then quickly, I just want to go to one, we'll go now to the second infringement decision. The decision is at Core Bundle 4, tab 33. And the CMA's conclusion in the second infringement decision is essentially encapsulated in paragraph 7.8 in chapter 7, which concerns economic value. Now, the decision is at Core Bundle 4, it's at tab 33, page 1334, EB, I'm told 1409. So, as I say, the paragraph 7.8 is in the chapter on economic value. And the CMA concludes at paragraph 7.8, the CMA has therefore properly considered demand-side factors in its assessment of economic value. Having carefully considered all the relevant evidence in the round, the CMA has concluded that demand-side factors in this case, including patient benefit, do not result in economic value beyond or additional to the economic value already reflected in the parties' cost-plus figures. So it is as plain as a pikestaff that nothing has changed on remittal. The first infringement decision said there were no demand-side factors that were relevant, including patient benefit. And in the second decision, the CMA doubles down on that conclusion.
Do you construe the first judgment of the CAT as saying that the CMA was not entitled to come to the same conclusion, or that it had to review the evidence and then keep an open mind as to whether...
Yeah, I mean, it could have doubled down. But in my respectful submission, that conclusion at 7.8 is a highly risky conclusion for the reasons I'm now going to come to concerning the compelling nature of the demand side evidence.
It's highly risky. Does that you just mean wrong? What do you mean highly risky?
Well, it's because it could be wrong, but it's highly risky because Pfizer adduced in the remittal further significant demand-side evidence which showed that the price clearly sat above cost plus. Now the CMA has doubled down on that and said there are no factors, all the 5 factors that I'm going to come to, none of those factors, none afford any probative weight in assessing the value of phenytoin.
I mean, but that's either just right or wrong. Why is it risky? I don't understand the concept of a risky decision.
Then I take it back. It is risky because it is doubling down on. I mean, it's risky. For example, the CAT in Phenytoin I said it was quite surprised that there was no value attached to phenytoin because of patient benefit. Quite surprised. Now, the CMA is entitled to double down, but having been given a steer by the tribunal that surely there must be some economic value attached to phenytoin, in my submission, it is risky. The CMA is entitled to do it as long as it does it fairly, but it is a fairly nuclear option because it is saying, it is risky because it is saying there are no demand-side factors, which would persuade a decision maker that the price should sit above cost plus. And that, in my submission, was a risky decision to adopt because it was clearly open to attack.
Is it at all relevant that following the decision, the price did come down? First decision was at just over £9 in 2017. There's been no challenge to £9. So it's not, and I don't think the cost plus has altered at all. I mean, there is an issue. Remember, we had it in Sinvan as to whether or not cost plus was pure or whether it was a price hovering around or in the region of cost plus, and a regulator might well take the view that if it's in the region of, broadly construed, you leave it alone. But the prices never went back to cost plus, did it? It went back to £9.17 or 18.
No,
It may not be relevant.
There was no reason why it should go to cost plus. It was in the PPS. We've addressed that. The OFT said that was it's a regulated price. You can't have price increases when it's in the PPS. You can only have price cuts. The OFT said it was an example of the DuPont exercising buyer power. You just cannot compare the PPRS price with the price which was in the market. But can I go, I'm conscious of time, I want to now go to the first material error, the failure properly to evaluate the expert medical evidence. For my Lord's note, we deal with this at paragraph 74 of our principal written submissions, but can I pick it up, please, with the CAT's judgment, and as we probably know, it's a core bundle 2, and I would like just to, as a starter, go to paragraphs 43 and 44, that's on page 668, and that's EB 743. So this is the medical evidence that was, clearly there was no oral evidence in the decision, but it had the two medical experts. But if at 43, generally, the expert evidence in this case was extensive. The tribunal heard evidence from 9 experts who submitted 14 reports for this appeal, with an initial 18 reports submitted in connection with the appeal against Phenytoin I decision. We list the experts, etc. The tribunal goes on, evidence is in accordance with the highest standards. In general terms, the medical experts provided, particularly in their oral evidence, real and helpful insight into the medical value of the capsules and into the vital importance of treating sufferers from epilepsy appropriately on a preventative basis. The tribunal then sets out who these medical experts were, and clearly, one looks at paragraph 44, they are very experienced people, professors in treating epilepsy. And we can see the amount of medical reports that were reduced, and they gave oral evidence and they were cross-examined. So that is the nature of the evidence. If we then go to paragraph 243 on page 850, and that's EB 925, hard 850. This is the section of the judgment that begins at 5. This is at 850, EB 925, 2/3 of the way down, the capsules and their economic value. What is economic value?
Sorry, did you say 243?
243, paragraph 243.
Of the judgment?
Of the judgment. 243, yeah. The meaning of economic value?
Yes.
Yes.
Yeah.
I don't want to refer to the passage from my Lord, which I think the tribunal could have picked a much better passage. But I do want to emphasise this paragraph
Yes.
because it does pick up on what my Lord did say at paragraph 97 of Phenytoin. This is the last sentence. This is a multifactorial test where it is incumbent on the competition authority to set out, describe and weigh the relevant factors with careful, objective clarity. It is a weighing exercise, and that is exactly what the CAT said a few years before. If my lords conclude that the tribunal was right to
Yes.
say that the CMA had not properly weighed the medical evidence, as we know, that is a question of fact and not an error of law.
Sorry, say that again. If we conclude the CAT is correct,
If my lords conclude that the CAT was correct to say that the CMA had not properly weighed the medical evidence, that is a question of fact, not law.
but if we conclude they were incorrect, is that also a question of fact, not law?
Yes, yes. Well, if they, yes,
So if the CAT was mistaken in its assessment of the CMA, of what the CMA did, you say that's an error of fact.
correct. Yes.
Even if it was, I mean, there's two ways of looking at it. I mean, it's quite an important point. If we construe the judgment as mistaken in the premise, namely when they say they didn't weigh it and they did, that's an irrational fact put in one way. If we construe the CAT as saying, well, the CAT had actually looked at all the evidence, addressed it in its own mind, and come to the conclusion that the CMA got it wrong and missed out A, B, and C, that would be a question of fact.
Yes.
But I think the CMA's point is that when you construe the judgment, that's not what happened. This wasn't a genuine assessment or conclusion by the CAT. It was jumping to a conclusion without reading the decision. And I'm not certain that's a question of fact.
I mean, with the greatest respect to Mr. Holmes skipped over many issues yesterday, as you'd expect. The bottom line is that after hearing a mass of medical evidence, the tribunal held that the qualitative assessment, the CMA's qualitative assessment of phenytoin's value was defective.
So you're putting together, they heard the evidence and all they had to do was set out a conclusion rather than analyse the evidence.
Well, they did analyse the evidence, and I'll come on to the relevant paragraph that you asked the parties about in a moment. The tribunal heard a mass of medical evidence about the therapeutic benefit of phenytoin, and it concluded on the evidence that the CMA's qualitative assessment was not good enough. The CMA said the medical evidence is a factor that affords no probative weight above cost plus. And as a finding of fact, the tribunal said that was wrong. That the extent of the therapeutic benefit of phenytoin was clearly, the value of phenytoin clearly sat above cost plus.
Yes, okay. And your argument, I suppose, is supported by the retaken decision where they say that some benefit over and above cost. Depends how you construe the paragraph. Let's assume you construe it as some benefit over and above cost plus had to be taken into account and became a legitimate part of producer surplus. You then get Mr. Holmes' point about materiality. So let's assume you're right.
Yeah.
And there was some value over and above. The CAT still thought the abuse was egregious.
Well,
or do you simply say, if we find that error?
If there was a defective, so there was a qualitative assessment by the CMA of the evidence. If that was defective,
yes,
but was not material, then we would not be here. So, as my lord said in Phenytoin, materiality is important. I will come on to it, But Mr. Holmes did not justify materiality by reference to any paragraph that we're going to look at now. He only justified his submission on materiality by reference to paragraph 320, which is the remade decision, and I will come on to it, but in my respectful submission, it is a travesty to say that the assessment which the CAT says was divorced from reality was not material by reference to the remade decision.
I think we need to let you get into the facts, don't we?
Yes, please. Yeah.
I read a lot into that tone of voice.
Just take my wig off for a minute. I'm reminded by my lovely junior silk. The conclusion at 277, yes, of... Yeah, I was going to come to that, but I'll read it. It's paragraph 277. The conclusion in the decision in the unfair limb discloses a number of errors that are sufficiently material
Yes.
to oblige us to overturn the findings of fairness. Yeah.
Yeah.
So the errors are material. If we, can I go to paragraph 246, turning to the medical evidence itself. That's at page 853. That's electronic bundle 928. Now here, this is where, and I won't, I mean, obviously my lords have read this, but this paragraph 246, 247 is where the tribunal, the CAT, assesses the medical evidence and criticises the CMA's qualitative assessment. So 246, the decision, so the CAT is looking at the decision, makes various findings in regard to the benefits or value of capsules. We focus here not on the conclusion drawn by the CMA, namely that the capsules were worth no more than cost plus, and that's what we're trying to hit at, namely that we're worth no more than CMA cost plus, but on the underlying reasoning as to the capsule's economic value. And as we know, the tribunal looks at, in some detail, the decision, and in 1 and then in 2 over the page at page 855. But if I go to subparagraph 3 on page 855, this is the paragraph that my Lord Justice Green was interested in, and then I think asked whether the parties could explore what the deficiencies in the CMA's qualitative assessment was. So let's just take this slowly. So the CMA's qualitative assessment of the medical benefits said that why nothing above cost plus, it's because the capsules suffered from significant limitation. So what were they? And it's set out there in that passage. But we can identify 3 alleged limitations.
This is in relation to, this is in the section of the decision relating to AEDs. So it's a relative comparison between first line AEDs and third line phenytoin sodium. I think that's the context. They're not, I don't think it's about the benefits of phenytoin sodium per se. I think it's about the relative benefits with first-line treatment. I might have got that wrong, but that's what it says in this particular paragraph.
in the decision, I'm looking at, just gone back to the decision at core 4. I'm afraid, they're saying that in this section the CMA, sorry, the CMA is saying that the price of phenytoin is unfair in itself, and in coming to this conclusion, the CMA has had regard to the following factors. And then at 664, it essentially denigrates the features of phenytoin. That's page 1199 of the decision, which is...
Yes. I'm just looking at it, I've got it here, and I think the analysis of the elaboration of that, from 673 onwards, and in particular the analysis of the relative performance vis-a-vis first-line AEDs.
Yeah.
I don't think there's any challenge to that relative analysis, that first-line AEDs have advantages in terms of toxicity, efficacy, adverse drug reactions, and so on, which is set out in the decision.
Yeah, clearly some AEDs perform better than others. The question is, can I just...
Yes, of course.
So reading, so this is essentially the CMA's qualitative assessment of the value of phenytoin from a medical perspective.
Yes.
And the first limitation, it says, which justifies no value above cost plus, is that phenytoin, so first, phenytoin compares poorly with other AEDs.
Yes.
So in other words, other AEDs may be more expensive, but they are better at treating epilepsy. Second, phenytoin was only, and we see there the word only. Capsules were only recognised as a third-line treatment for patients during the... So it is, again, downplaying phenytoin because it is only a third-line...
But is that incorrect? Do you challenge that proposition?
No, but...
Relative to other AEDs?
What I do challenge is essentially the finding in the decision that third line means third rate.
Well, it means inferior, which was then, it means inferior to first line because it's not prescribed.
Well, no, not necessarily. Well, no, that's it. Second, phenytoin was only recognised as a third line treatment.
Yes.
I'll continue. Third, the third limitation, it was prescribed because of the MA Arch guidelines.
Yes.
And then not because of the therapeutic benefits of capsules relative to ARDs. So it was prescribed because of the guidelines, not because of the therapeutic benefits of capsules. So those are the three limitations. And the tribunal was, in my submission, wholly correct to criticise the CMA's qualitative assessment. It says at little Roman 2 at the bottom, the suggestion that capsules were not medically beneficial in the appropriate case is a fundamentally incorrect statement containing an implied criticism of conscientious doctors treating epileptic patients. The tribunal refers to the extensive evidence of the medical experts. The tribunal says, halfway down that part, the short point is that the prescription of phenytoin sodium is a medical judgment call, and when it is made, it is done to minimise or eliminate seizures in circumstances where there is no other better treatment. Of course, and this is the route to the second point that I made, of course phenytoin sodium is used only as a third-line drug, but that says more about its utility than anything else. Phenytoin sodium is deployed when other drugs do not work and in appropriate cases can be very effective. The CMA's qualitative assessment of the benefits of phenytoin sodium is somewhat divorced from reality. 247, the finding in the decision that there was no economic value or patient benefit beyond CMA cost plus is not sustainable. The medical benefits of the capsules are given insufficient weight. It is obvious that the capsules bring with them significant patient benefit. That much is obvious from the medical evidence that we heard. And one cannot shy away from the fact that this is a finding of fact based on medical evidence by the tribunal, disagreeing with the CMA's qualitative assessment.
Can I just ask this, because the passage of the decision that's cited and then criticised, I don't think I see in that passage a conclusion that capsules are not medically beneficial in the appropriate case.
Yeah, Section 2 does go through the benefits of phenytoin sodium in considerable length.
With greatest respect, if one looks at the last two lines of that passage, demand for the products was satisfied, predominantly by barriers to switching patients to other treatments, that is the guidelines, not because of the therapeutic benefits of capsules.
Relative to other AEDs.
Relative to other AEDs. And what?
You're saying they're not better than other AEDs. It's not saying, I think it's not saying that they have no medical benefit in the appropriate case. It's recognising they do, because that's the cases that there is.
Well, if they do, and we saw all the medical evidence play out, and it is quite clear that the CMA was downplaying the medical benefits of phenytoin. If my lord is correct, and everybody is ad idem, then it is still clear that phenytoin should be given value above cost plus.
That's the crux of the point. Assuming that the CMA got it right, that there is residual benefit in the third line treatment to that category of legacy patient for whom it is benefit and it prevents epileptic fits and so on and so forth, was that given sufficient weight? Isn't that the real issue? Yeah. I'm not certain there's a dispute about the cat is actually properly disputing the facts. Now, I think it's a sort of a consequential but nonetheless relevant question. Is the cat right to say that insufficient weight was given to that benefit which the CMA found? Well, anyway,
I take the point, but then I will bank the finding of fact by the tribunal that phenytoin brings with it significant patient benefit. Significant patient benefit. And is very effective. And the tribunal says that means that there should be a price that sits above cost plus. Without the conclusion and two, the extent to which the appellants were entitled to a price at above CMA cost plus is not a point that receives separate consideration. Simply asserted that the economic value of the capsules sits at cost plus without considering any of the factors that might or might not produce a surplus. A conclusion that the economic value of the capsules sat at CMA cost plus was a finding that was not open to the CMA. And really, the cat in Phenytoin I said it was very surprised that there was no economic value above cost plus. And then we have more medical evidence, we have cross-examination, and we have a clear finding of fact that phenytoin provides significant patient benefits. And but again, I'll make this a few times. My Lord said yesterday, we've got to be very careful that the law, Section 18, the law, is not going to mess up the pricing of generics.
Yeah.
And if you have a trial where the undertaking shows that its medicine produces significant patient benefits, quality of life, and forgetting the avoidable costs that I'm going to come on to say that the significant benefits is not a factor that would justify anything above cost plus, that is a sad day for the pharma industry, I would say.
But you can assure me we won't say that. We will stick very much to the facts. We're conscious of this, but what about aspirin? Aspirin has significant benefits, yet it's priced at £1. You can buy it in supermarkets at £1, £2 a box, which must be not far above cost of production and distribution.
Well,
I mean, it's not at this level. I mean, there's a lot of policy involved. In the sense, government policy about what you pay and what you don't pay.
Correct, and I'm going to come on to the government policy in a moment.
Yeah.
But that is a good example because government policy says with generics, competition should drive down prices.
Yeah.
We'll come on to the intervention, which was through Scheme N, to ensure a fair price. So it may well be aspirin now is like a commodity.
Yeah.
And one should not be looking at it from a producer surplus perspective. It is a consumer. It is a benefit to the NHS. It's a consumer surplus. To flag what I'm going to submit, the department valued phenytoin at £30, insisted on £30. But then, because competition came into the market, it got a better deal. It went down to £20. Pfizer benchmarked at a 50% discount from the £30. So the NHS gets consumer surplus by instilling competition in the market. And I'm tired, I don't necessarily take that, but branded aspirin can be expensive. Panadol.
That's from Mr. Donahue, who's been paid too much. Can I suggest when you have a headache, you go to Tesco's or some other large
Other supermarkets are okay.
Can I just row back because I need to get a move on. In my submission, the tribunal is saying in these paragraphs that the CMA made a material error by not affording phenytoin any value above cost plus because of the significant medical benefits.
I get that point, and I think we recognise that's not an easy issue conceptually, morally, philosophically, or legally.
No. But we did adduce significant medical evidence to show how highly effective phenytoin is when other AEDs do not work. And to somehow say that doesn't matter.
I think that's common ground.
Well, but to say that it doesn't matter and all you're entitled to is a cost plus. Can I just
understand
Of
that,
course.
by the way? Because it is what the CAT said in this paragraph you've just been showing us. My understanding of the reference to demand for the products being sustained predominantly by barriers to switching of patients to other treatments. I mean, in paragraph 2463(1), the CAT says the paragraph suggests barriers were imposed by the seller. I don't see why that is the case, but I know it's not correct. And were imposed for reasons other than patient benefit. Well, that's not correct either. But I don't understand where the CAT gets that from that paragraph. My understanding is the reason that patients are kept on, as was said before, legacy patients are kept on phenytoin rather than switched to first or second line drugs isn't because the first or second line drugs don't work. Is that right? It's because there are issues about switching them from a medication which does work.
No, so if you're unfortunate to have epilepsy, it's devastating, as you know. And you try the first line, it doesn't work. You try the second line, it doesn't work.
Yeah.
You have the third line. Sometimes the third line is used in conjunction with a second or first. But the neurologist will then, I'm going to put you on phenytoin, which is a third line, which is the
But that's not what this is talking about. It's talking about switching patients
Yeah, but
to other treatments.
So you're now on a third line. There are some products, phenytoin is one, where subsequent to the launch, the MHRA issued guidelines which said that it would be advisable to keep that particular product around with the patient for psychological benefits.
Yeah, I mean, I understood this is what that paragraph was, the decision that's quoted was dealing with, is patients who have been on phenytoin for some time, possibly because it was at the time they needed an anti-epilepsy drug, the only drug. We now know that there are better drugs, first and second line. That's what first and second line means, I think.
No, that's not how the medical evidence played out. That was essentially the CMA's message, which was that third line is not as good as first line. Now, first line, it is the first port of call, but third line is very, very important.
Yeah, I'm not saying it isn't for a person who's on it.
Yeah.
But I'm trying to understand what switching patient. Well, it talks about demand being sustained by barriers to switching, which I understand comes from the MHRA guidance about continuity of supply. And in my rather simplistic head, I had that for some patients for whom phenytoin works, and that's the drug they've always been on, and it works.
Yes.
You don't switch them off it to a first or second line.
No,
even though first or second line drugs might work.
the switching has not really got anything to do with first, second, or third line. The switching is to do with the nature of the AED. So there are certain AEDs where the government has said, with this particular AED, and I'll check, I think it could be a first line or second, but there are certain AEDs that have certain characteristics, how they interact in the body, where the government has said it is advisable, it's not a requirement, it's advisable to keep on the same brand. But it's got nothing to do with first, second or third line. It's got everything to do with the nature of the AED. And the guidelines listed several AEDs which says that it is advisable to keep the patient on that brand. But what the CMA is saying there is essentially the demand is predominantly is the continuity of supply, not because of the therapeutic benefits. And Professor Walker gave evidence and said he would prescribe phenytoin to a patient, a new patient, for whom first line and second line were not working. And then you get into whether you should switch to the NRIM phenytoin capsule. So,
Just on a point of detail,
yes.
I thought I'd read somewhere that the sales of phenytoin are falling.
Yes.
And that's because they're not being prescribed to new patients, either at all or very much.
Well, that was that. Well, it has to be very careful what reads in the decision, because the qualitative assessment has been found to be defective. There's lots in the decision. But yes, but my lord is right.
Simply a point of detail. Is it right to say that phenytoin is not being prescribed to new patients?
No, it's not correct.
Right.
There's data in the decision which says that it was only very rarely prescribed during the relevant period.
Well, then Mr. O'Donoghue is going to go through the.
But I don't understand that to have been a factual conclusion which was challenged. It's not one that the CAT addresses. They don't really address the evidence of AEDs, other than in the broadest generalisations.
I mean, this is what this is. I mean,
you may be right, but we don't have the CAT's analysis of the detail of the evidence. It's a difficulty, really.
Well, the tribunal. Can I just read? I mean, this is Professor. This is the first report. First one. Exposition paper. So the exposition paper. So there were position papers. I'll just read it. I have seen patients who have.
Reference.
Yeah, it's supplemental bundle 1549.
Is this a reference? What's called a reference supplementary bundle?
Yeah. Tab 51. 1549, which I think is the same for everybody.
1549, paragraph
2.4.
2.4.
Yeah. So I have seen patients who have never tried phenytoin before, when phenytoin has ended up being the only medication which has controlled the seizures. For example, one of my patients is a 19-year-old man who's referred to me within the last 5 years with almost continuous seizures, resulting in persistent jerking of his right arm and leg, so he could not walk or care for himself. He had tried multiple medications and had spent months in hospital. It was only the introduction of phenytoin that gave him any control of his seizures so he could return home. To say, as Professor Sander, that's the CMA's expert, that he does not think that any neurologist would recommend phenytoin to be used by their family and friends is, in my experience, not correct.
In fact, the paragraph 2.3, which precedes this, is the one that takes the person who's always been on phenytoin, but was attempted to be taken off it because it's, quote, an old drug, to be put onto newer drugs, but, quote, these attempts all failed, so he's remained. So I think you'd say that was evidence, medical evidence, of somebody not switching off phenytoin, but for medical reasons, rather than what they call barriers to.
Yes.
But, okay, I mean.
And it's very important. Okay, so
the trouble is, without seeing this level of underlying medical detail, it's quite difficult to just.
Well, it would be a question of island hopping. I mean, there was days of medical evidence, and when the tribunal is saying it is a fundamentally incorrect statement, just basically say you're only getting prescribed this because of the continuity of supply, not because of any therapeutic benefits. One can understand why, from our perspective, it is a fundamentally incorrect statement.
Yeah, well, you'd say, and this was picking up what I was trying badly to put to you, to get your help on anyway. I mean, going back to the paragraph in 3 that's quoted, that the CAT says barriers to switching is the MRHO guidance and continuity of supply, presumably, And what I understood was that was to do with something other than a situation where no other drug actually worked. So you'd say, actually, that's wrong because there are circumstances where the barrier to switching patients to other treatments are because the other treatments just don't work.
But the word is predominant.
But
We've seen a piece of evidence, we
Yeah.
haven't seen the rest.
But there was I simply, if we can't iron hot all the evidence, the tribunal has found that the conclusion by the CMA that medical benefits do not justify any price above cost plus was not sustainable.
I think that's got to be the point, because I'm not even certain that that little subparagraph 2 follows from 3, the quotation from the decision. What's quoted here is a relative assessment. They don't go on and say that in an appropriate case, phenytoin sodium isn't valuable. And the decision doesn't make that point. I mean, is that but I do take the point that if you take the decision, which recognises that phenytoin sodium is an important medicine in the appropriate case, where first and second line doesn't provide effective treatment, that there is a value.
Yeah.
That flows from the decision itself. So your point really has to be that given what the decision found about the value of phenytoin sodium in capsule or tablet form, I suppose, for this reason, they didn't attribute sufficient value to it.
Correct. I mean, in truth, that is exactly what we argued first time round. We had Professor Walker, and we said, look, in the decision, the CMA is saying this does have value, but you're now saying that it doesn't have any value above cost plus. That can't be right. The tribunal in Phenytoin I remitted it because they thought that was questionable. The paragraph 7.8 of the second decision doubles down and says no, there is no economic value attached to the medical benefits of phenytoin. And we say that is fundamentally wrong. How much value then is a question of evidence, and I do need to address Mr. Holmes' material error. But how much value is important? So yes, the medical evidence says that there is value above cost plus, but the medical evidence in itself, Professor Walker does not tell you how much, but it sits above cost plus.
Hang on, why does the medical evidence say that the economic value sits above cost?
No, it does, sorry, but it doesn't tell you by how much to pick up. The medical evidence says there is a significant value, and we say...
Sorry, it says there's a significant benefit.
Benefit.
Yeah.
Well, if it has a significant benefit...
As every drug has, if it works. So that's the mismatch I'm not understanding at the moment. Why does significant benefit translate to significant value?
Well, then you'll never... well,
That isn't already built into cost plus, obviously.
two reasons. First, if one goes down that route, that whatever medical benefit there is should never sit above cost plus. So you can say there is significant cancer treatment, significant whatever treatment, but one then says, well, that's the same with all drugs. And so the CMA is entitled to have cost plus. Then that is extremely bad news for the pharmaceutical industry. And second reason is that is not how the Department of Health approaches it. So I just said that the medical evidence tells you that there is an economic value above cost plus because of significant patient benefits. And I haven't even got into avoidable cost yet. then you know it's above cost plus because there's a significant patient benefit. Where do you go from there? And we, at the trial, met the delta by showing the tribunal that there was a £30 valuation to phenytoin by the department itself, and we adduced significant quality evidence that Mr. O'Donoghue will refer to, which is the department's own way of valuing a medicine, whether it gets value for money. And the quality does two things. It looks at the patient benefit and it looks at the avoidable cost. So the quality does two things. It looks at the patient benefit and it looks at the avoidable cost and asks, in essence, whether this drug is value for money. And we adduced evidence from Dr. Schedule where he replicated the quality analysis, which showed that in September 2012, phenytoin was value for money. So we took the medical evidence, said, you're wrong to say it just sits at cost plus. Now let's have a look and try and quantify that value. And we did that, well, we'll come on to it, but we showed the tribunal there was significant avoided costs, which every single of the CMA's witness accepted was relevant to economic value of any drug. So it's not just the medical evidence, it is the avoided healthcare costs. So so in order to look at, try and quantify some of that value, which the CMA did not do, we relied on the £30 valuation from the department. We looked at the avoided costs and the Department of Health saying, well, you've got to look at avoided costs for phenytoin, and we adduced quality evidence. And so we did, and this court in Lyothyrian said, well, there's an evidential burden on pharma undertakings to try and show value. That's what Pfizer did. Yeah, I've read that, but at 247, the finding in the decision there was no economic value or patient benefit beyond CMA cost plus is not sustainable. The medical benefits of the capsules are given insufficient weight. It is obvious that the capsules bring with them significant patient benefit. That much is obvious from the medical evidence that we heard. And that, in my submission, is a finding of fact. The tribunal...
Sorry, which paragraph you know?
247 is a finding of fact. 247.
Yes, yes.
Can I just quickly...
Can I ask a related question, which is probably throughout? In the retaken decision, the CAT introduced the notion of the fictitious consumer.
Yes.
Who has characteristics, a limited income, a certain amount of knowledge similar to a GP, not a consultant, and is therefore takes a fairly selfish view as to what he or she will pay for a drug.
Yes.
Some of the points that you're raising reflects a concern we had about that particular test, which is that the normal way of looking at it is, that, if you like, the state as the buyer, and the state does take into account a range of non-personal characteristics, for example, risky research and development, the requirement to defray those sorts of costs. They may take into account and pay above cost plus because they recognise all the sorts of factors which came out of the quality evidence.
Right.
But that would sort of be precluded if the CAT was right, that you look at the position of the subjective, individual, fictitious consumer with a modest income,
well, no,
a modest level of
not
knowledge.
Modest, wealthy, above average income.
Above average, but not particularly wealthy.
Not oligarch, but.
Okay, well, that seems slightly undemocratic. So the less well off. But I mean, isn't this an important point about the perspective from which one measures fairness, which is whether the state will take into account a wide range of factors beyond the position of the individual for whom they act as a proxy.
Yes, I mean,
the sorts of factors you're referring to are not really the sorts of factors an individual would take into account, are they?
No, can I just very quickly meet Mr. Holmes's case, because he said okay, there may be a defect in the medical evidence assessment, but it wasn't material.
Okay.
And he did that by reference to paragraph 320, which is at page 906 of the, and it's at EB 981.
Yeah.
So Mr. Holmes relied on this, even if there is a defect in the reasoning, well, it wasn't material. And we say this paragraph does not even begin to support that submission. And I've got 3 short points to make. The first reason is contained in paragraph 322. So, paragraph 322, where the tribunal says, we also accept the capsules manufactured by Pfizer do real good AEDs that ameliorate seizures, significant and unquantified human benefit. They also deliver significant benefit in the form of avoided costs, the cost of treating a seizure, and I'll come on to that, the cost of the wider, we accept that these benefits vastly outweigh the price of the capsules, albeit we're in no position to quantify those benefits. So my first point is, you have there in this very paragraph, the tribunal saying, well, the medical benefits and the avoided health care costs vastly outweigh the price of the capsule.
What do they mean by price? Do they mean price or do they mean cost plus? Because it's a bit odd to,
Yeah, it does actually.
It says price. I mean, you win either way if it's beyond price.
Yeah, that's right.
It's floor.
The CAP was in a position to quantify the benefits because it had the £30 valuation, it had the quality. But I will bank the vastly outweigh the price of the capsule. So the tribunal is saying that these benefits have a monetary value. That's the first point. The second point is, if we go to subparagraph 3.2, and I'll come on. So this is turning then, so this is on page 907, over the page. Turning then to the ultimate consumer as we have defined them. And that is going back to paragraph 296, which is the fictional patient. 298, sorry, 298, the fictional patient. We are assuming a well-off but not unlimited wealthy patient. A well-off but not unlimited wealthy. So the unfairness in this paragraph is being judged by reference to the hypothetical wealthy patient, not by the Department of Health. And if, as we say, the tribunal did not have jurisdiction to apply a fictional patient test, or it was unfair, then what the patient would have done is also irrelevant. And I would add, because I think it is a valid point, one of the really gut-wrenching aspects of the unfairness is that we never had a chance to say how crazy the fictional patient test was. And even on the evidence before the tribunal, you have a wealthy patient who has epilepsy, no, can't work, no family life, and the evidence before the tribunal was the cost, the daily cost of phenytoin was £1.93. £1.93. So you get here that this wealthy patient is not going to pay £1.93 a day to be seizure-free. And we say that is just crazy.
What are you banking something in this paragraph?
I'm banking. Well, I'm not banking a finding of fact. I'm making a submission that you cannot. Mr. Holmes said, look, there was a grotesque mismatch. There was no material error in the medical assessment. And all I'm saying here, well, you only say that because of the fictional patient. And if it is wrong to apply a fictional patient test, it must a fortiori be wrong to test unfairness by reference to that patient. And the third point I would make as to why this paragraph does not support Mr. Holmes's, well, it was not a material error. One goes back to subparagraph 3 on page 906. And then going to 1, I know the court has this point, but the fictional patient, the wealthy patient, is only paying for a placebo. He's paying for the psychological benefit of taking phenytoin. The hypothetical wealthy patient is excused from paying anything for the medical benefit of obtaining seizure freedom. This cannot be a test in the pharmaceutical world, where you have a hypothetical patient which is not paying for the medical benefit. And if one, as a separate point, if one looks at Little Roman 1, it is rewriting the law on comparables, because it is saying, yes, you can have a valid comparator. The phenytoin tablet may be fantastic and may be a lot more costly, but that's beside the point, because the focal point, the capsule, the pharmaceutical company has got to prove something over and above that. So it's rewriting the law on comparables. The capsules deliver no medical benefit that could not equally be delivered by a differently manufactured capsule or tablet. Why would you, if the capsule is, the tablet price is a valid comparator, why would you ignore the tablet price and say that Pfizer, for some reason, has got to prove that its capsule is better than the tablet? It's rewriting the law on comparables. This paragraph, is, with greatest respect, just does not support Mr. Holmes's submission that the defective medical assessment was not material. That's I've taken a while. I will speed up.
Just one second. The hypothetical fictitious consumer, we do want to know at some point why you dislike the test. I mean, you've got your written submissions, but why does that person have a higher than normal disposable income? Does that mean that someone who doesn't and is at the more disadvantaged level of society is not the relevant benefactor, or the fact that they can or can't afford something, or they can't afford it, it means that tough, they do without it?
Well,
why do you get rid of the prescription regime?
Correct.
Which needs to be abandoned?
Correct.
Why?
Precisely.
And how do you take account of some of the broader macro considerations which apply to the pharma sector if you have this narrow individual who is your benchmark?
This was never, ever on the cards. And we would have had a lot to say about it, picking up some of the points my Lord has just made as to why the fictional patient test is not fit for purpose.
But you accept you have to look at it as effectively the state who has a benevolent view of both the position of the individual and the policy considerations of
Paragraph 7 of the Cat's judgment says the patient does not pay for the...
Yes, the state does.
The state does. And the state has lots of policy considerations. So when we see after lunch the 30, why did the monopolist buyer insist on £30? Well, it came to a £30 valuation. One of the considerations would have been the avoided healthcare costs. Yeah. So it is at the races. You're looking at at the benefit, the avoided cost, the benefit to the purchaser.
2.
Yes.
All right.